Hello, America. Good afternoon. My name is Jonathan Arias. I'm the lead attorney at the Onyx Group, a landlord attorney, multifamily housing attorney, and it just got spicy in Orlando, Orange County. I told you last week that the county commissioners voted to put on the next ballot a rent control measure on the next ballot for their election. And so now it's gotten spicy. So apparently here, the Florida Association of Realtors and the Florida Apartment Association said, heck nah, homie. It ain't going down like that, homie. So they filed suit. I'm gonna read a little bit of this article and then we're actually gonna look at the lawsuit a little bit. So here's what happened. Realtors sue to have Orange County's rent control measure tossed from ballot. This comes from the publication Florida Politics, and this reporter, Scott Powers, came out August 16th, so that's 2 days ago. Realtors, apartment associations want Orange County's rent control proposal declared invalid. Realtors and apartment owners have sued to get Orange County's rent control measure thrown off the November general election ballot. The suit filed by the Florida Association of Realtors and the Florida Apartment Association asked Florida's Ninth Judicial Circuit Court in Orange County to declare that the rent control measure ordinance approved last week by the Orange County Commission is invalid because it failed to prove a housing emergency as is required by state law for such measures. The suit also asked the court to declare that the ballot language is affirmatively misleading, fails to fairly inform voters of the chief purpose of the proposal in clear and unambiguous language. We're going to read about that. I'm going to read two more paragraphs, then we're going to hop in it. For either or both of those counts, the organization wants a judge to issue a permanent injunction that will prevent Orange County Supervisor of Elections Bill Cowles from placing the measure on the November 8th general election ballot in Orange County. Court proceedings drag out too long, then they want to have Cowles' office include notes with ballots instructing voters that the question has been canceled, and then to not bother counting any votes that might be cast on the issue. All right, so let's check this out. This is Orange County clerk. I did a record search for this case. It was filed on the 15th, 3 days ago, by the Florida Association of Realtors, Florida Apartment Association against Orange County, Florida, and Bill Cowles as the Orange County Supervisor of Elections. Nothing has happened on this case because it was just filed. There's just today a case management order. We don't have to get into that. That's boring stuff. But here we are at the complaint. So the top, here are the parties. It was filed the other day at 4:50. So yeehaw. So let me jump into the actual meat and potatoes. All this stuff is basic information you don't need to know too much about. All right, yeah, let's go here. So I'm jumping down to paragraph 13. On March 8th, 2022, Orange County Commissioner Emily Bonilla submitted a memorandum and report to the Orange County Mayor and County Commissioners regarding a proposed rent control ordinance to be discussed at the board's meeting on April 5th, 2022. So I jumped down to the plaintiff's reasoning for why this should be declared invalid and this injunction should go forward. So they're discussing and laying out what happened here. At the request of Mayor Jerry Demings and in preparation for the board's discussion, the county attorney for Orange County prepared a memorandum addressing Florida's statutory restrictions on rent control measures and relevant judicial precedents. A copy of the attorney's memorandum is attached as Exhibit A. We're not going to look at it because they address all the relevant portions. The county attorney's memorandum identified the conditions and restrictions imposed on local governments that seek to adopt rent control measures under the grave housing emergency exception. In addition to discussing the procedural restrictions, the county attorney's memorandum analyzed the statutory term grave housing emergency and traced its origin to the U.S. Supreme Court decision. The county attorney's memorandum also examined the history of litigation regarding that. Here we go. Based on upon a review of these authorities, the county attorney's memorandum concluded that it was unlikely that a shortage of housing, increase in the cost of living, or an inflationary spiral alone are enough to establish a housing emergency so grave as to constitute a serious menace to the general public. Instead, the county attorney's memorandum stated that a rent control ordinance in Orange County will likely need to contain findings and recitations that are more similar to the Levy case. That there was a very great shortage in dwelling house accommodations in the cities of the state to which the acts apply, that this condition was causing widespread distress, that extortion in most oppressive forms was flagrant in rent profiteering, that for the purposes of increasing rents, the legal process was being abused and eviction was being resorted to as never before, and that unreasonable and extortionate increases of rent had frequently resulted in 2 or more families being obliged to occupy an apartment adequate only for 1 family, with a consequent overcrowding, which was resulting in insanitary conditions, disease, immorality, immortality would be dope, immorality, discomfort, and widespread social discontent. Stated differently, the findings must establish both the grave housing emergency and the effect that the emergency is having on the general public, such as like they stated there. Not only would Orange County need to recite these findings in a rent control ordinance, the county attorney's memorandum advised that Orange County would need evidence to prove the existence, in fact, of a grave housing emergency in the event of a legal challenge. Orange County would also need evidence to provide that its rent control ordinance is necessary and proper to eliminate said grave housing emergency. Finally, the county attorney's memorandum noted that there was no apparent record of any local governments in Florida imposing rent controls pursuant to Section 125.0103, since the statute went into effect on May 21, 1977. All right, so that's their first piece of evidence, is that the actual wording is off and there's no evidence that we have a grave housing emergency. All right, next piece. I think they lay it out pretty well, personally, but we'll see. We'll see what happens. Following discussion at a meeting on April 5th, 2022, Orange County Board of Commissioners instructed staff to retain a consultant to evaluate housing costs and the effectiveness of rent control measures. Orange County retained a consulting group, the Community Solutions Group of GAI Consultants, to evaluate and document local housing conditions to determine whether they rise to the level of an emergency, to estimate the number of units that could be affected by rent control measures, and to comment on the likely effectiveness of those measures if implemented. Okay. The GAI report ultimately concluded that the issues driving housing costs in Orange County were deeply structural and a product of regional and national market influences, likely beyond the control of local regulation. That in the biz is what we call a smoking gun. If the consultant you hired is like, hey, basically what you're doing here probably won't fix this. But apparently they went forward anyway. The issues stem mostly from inadequate housing production over years, which a temporary rent ceiling would do little to correct. The GAI report found that rather than eliminating a grave housing emergency, rent control measures consistent with Section, I won't say it anymore in the interest of time, Section 125, I'll just say that, may impede the objective of speeding overall housing deliveries, as well as create a number of unintended consequences. Smoking gun. As to each of the GAI report's major findings on specific issues evaluated, Orange County's retained consultants reached conclusions inconsistent with the existence, in fact, of a grave housing emergency that would be eliminated by the adoption of a rent control ordinance. All right, here goes the third. At a meeting on June 7th, 2022, they basically did it anyway. That's what that goes into. I'm going to skip it because we already have talked about this. So what they're saying is, as a result, it doesn't satisfy Section 125 and is therefore invalid. I'm going to skip that as well. And then also they also state that the language, there's an issue with the language. So paragraph 37, the ballot statement specified in the rent control ordinance is affirmatively misleading and fails to fairly inform voters of the chief purpose of the proposal in clear and unambiguous language. As described above, The rent control ordinance requires the following ballot statement to be provided to voters on the November 2022 referendum election. I won't read it, but here we go. 39. This ballot statement omits any reference to other aspects of the rent control ordinance that may be significant to voters. Separate limitations on rent increases in section 25384, the open-ended delegation of authority to Orange County Planning, Environmental, and Development Services Department to administer the ordinance's rental unit registration process in section 25387, and the ordinance's enforcement and penalty provisions, including the potential assessment of punitive damages, attorney shifting, civil penalties, and imprisonment in the county jail in section 25390. A ballot title and summary must be accurate. The ballot statement must provided for the voters in the rent control ordinance contains omissions and affirmative misstatements that render it defective under section 101.161. All right, so here's what they're looking for. They're looking for a couple things. Number one, declaratory judgment. So they're saying, hey, this ordinance is invalid. So that's the first thing. Number two, they're looking for an injunction. So basically, like the first one, I'm not going to get into the legal nuances, but the first one is declare it invalid. The second one is saying, hey, an injunction would say that it can't go forward. It's basically that's what an injunction does. The judiciary says, hey, this can't go forward, and again, it'll be invalid. Number three, declaratory judgment against the ballot statement for the reasons we mentioned, and an injunction against the ballot statement for the same reasons. And then they're saying that they want to basically want the court to say that that Orange County has improperly exercised its powers under the state of Florida by adopting the rent control ordinance. And so that is that. This law firm, I've seen them around, Schutz and Bowen in Tallahassee. So it's getting spicy, y'all. It is getting spicy. I just did a video on the fact that they passed this rent control ordinance to go on the ballot, and a couple days later they were like, "Oh heck nah, not while I'm here, homie." So listen, if you have a question about this issue in Orange County or any landlord, tenant, multifamily housing matters, you can reach out to me, honestgrouplegal.com. I would love to hear from you. Thank you very much for your time and your attention. We're going to keep monitoring the situation, what happens in this case, and I'll keep making videos about it. For now, God bless you. You have a wonderful day. Bye-bye.